First of all, a little bit of a recap, because so much has been happening over the last few months that has been clearly overwhelmed by furlough, that you might have missed a few of the changes that happened in April. Now, there's nothing really major here, but certainly there are things, of course, that you do need to be aware of. So obviously, as per usual, statutory sick pay, maternity pay, etc. Those pay rates have changed at the beginning of April, as they do every year. The compensation limits for tribunal awards have increased, as they do every year. The calculation of a week's pay has been changed to a 52-week average, and this is in reference to calculation of holiday pay. Sorry, I should have put in the word holiday pay in there. So yes, that has now changed to a 52-week average from the original 12-week average that we had before. So that happened in April as well. For those of you who are aware of, or perhaps even took advantage of, the Swedish derogation in the agency workers regulations, which essentially enabled employers to get around this 12-week equalisation of a number of pay and benefits for agency workers in comparison to permanent workers. The loophole, for want of a better way of putting it, the Swedish derogation, has now been removed. So you can no longer use that. It wasn't something that was particularly commonly used by employers, I've got to say, or in fact by agencies, but I know that some did, but that's now gone. So if you are, your agency should have told you in any case, if you were using that. And then if you are an agency, then you've got to tell all of your agency workers that this has been removed and that they now do have their normal rights under the agency workers regulations. So that's some of the changes in April. Now some of the other changes. So we have now got an extension of the right to the Section 1 written statement of main terms and conditions. And that's been extended to workers as well as employees. It only used to be for employees. It's also now become a day one right. Okay, so this is all part of the Taylor report. So that if you remember, the Taylor report was published about a year, 18 months ago. Time flies, so I must admit I can't remember quite exactly when it was published, but the Taylor report looked at essentially the gig economy and trying to ensure that there are greater protections in place for the more vulnerable workers within the economy, and this is one of those. So giving workers, and particularly, say for example, particularly 0 hours workers, the right to these written statements of main terms and conditions. And they've also put in there the requirement for more information. And so this actually does trigger perhaps a review of your employment contracts, because your employment contracts have now got to, for example, include specific information about working patterns. So you can't simply say that, we'll tell you what your working hours are going to be. You've got to have more specific information in there about working hours. You've also got to have specific information in there about training that you're going to provide, which is something that has never generally appeared in employment contracts before. So you've got to include that information in your contracts now in order for you to comply with this change as of April. Obviously, we're happy to help you with any review of employment contracts if you would like. For those of you who are retained clients, then obviously please do just get in touch, and that's almost certainly just covered by the arrangement that we have with you. But it would be worth us having a look at those contracts. The threshold for employees to be able to force an information and consultation arrangement. So this is where an employer is forced to essentially put in place a workplace committee of some sort. That was provided for under the information and consultation regs of quite some time ago now. And those information and consultation of employees regulations really, certainly I've seen very, very little use of them. When I say very little use of them, I've seen in reality, they are not being used by employees to force employers to put arrangements in place. Now, of course, this will be because many employers already have arrangements in place, or employees just simply aren't bothered by the fact that there aren't arrangements in place. But one of the things that has been changed is this threshold has been changed from 10% of employees down to 2% of employees to force a change, to force an employer to put in these arrangements. I don't think that's really going to change the reality of the situation in terms of these regulations. I'm assuming that the government is expecting that by lowering it, they would expect more applications to be made by employees, but I must admit I don't see it. Termination payments, so all termination payments over the £30,000 limit that most commonly, you see in redundancy situations or alternatively in settlement agreements, they're now subject to the Class 1A national insurance contributions. And also interestingly, as part of a finance act of a couple of years ago, which was implemented in 2018, the government has now actually given scope for this £30,000 limit to be amended at some point in the future. What it will be amended to, whether it will be increased or decreased, who knows. It has been £30,000 certainly for as long as I can remember. So it is due a change, but whether the government is going to use it as the opportunity to reduce the use of it to the extent that the government can then earn more taxable income, or whether they'll increase it, we'll have to wait and see. A very welcome introduction of parental bereavement leave and pay was introduced, so giving those parents who have had the very unfortunate incident of losing a child under the age of 18, or also for stillbirths, there is 2 weeks leave and pay for those parents. And I won't get into the next one in any detail, but the government guidance on the treatment of salaried hours for work for national minimum wage purposes has also been amended. If you want to pick that up offline with me, then obviously happy to do so. So what's on the horizon? So what is actually coming? Because again, we've been overwhelmed by furlough. We've been overwhelmed by Brexit. Although I appreciate that we haven't heard an awful lot about Brexit, but the sort of ongoing employment consultations and legislations that are in the pipeline haven't been talked about a huge amount over recent months. So I wanted to cover some of those now. So in April 2021, we've got a number of things that we are expecting. Some of them are confirmed and some of them we're just simply expecting. So first of all, we have got a change to the formula for post-employment notice pay. Again, a rather technical change, one that I won't get bogged down within this seminar because I've already given you some maths, and my apologies for that. But essentially, there is draft legislation for amending the way that the post-employment notice pay is calculated to avoid unfair outcomes which then occur because of the difference between statutory notice periods of calculated in weeks and contractual notice periods calculated in months. So the off-payroll working rules of IR35, of course, come into force on the 6th of April 2021. They've been delayed from April of this year because of the coronavirus epidemic. So that's simply been delayed. So if you use contractors, self-employed people within your business, consultants, then we need to have a look at how that may affect you, because it might be that we're needing to put them onto the payroll and process them as we would for employees and workers. And then we've got a full government response to the Law Commission on Employment Law hearing structures expected. Now, what that is essentially meaning is that there are a number of important changes that have been recommended as part of most of it coming again from the Taylor report. So there is currently a £25,000 limit for breach of contract claims in the Employment Tribunal. We are expecting that to increase because the government wants to ensure that more employment claims are coming through the Employment Tribunal system rather than going perhaps to the Small Claims Court or the High Court, I should say, for those claims of that sort of value. There is the possibility of the 3-month time limit being increased. This is mainly in relation, or there's the most pressure in relation to this time limit increase is in relation to discrimination claims. because there is a real concern that there is an access to justice problem, and particularly in relation to ongoing harassment that people experience at work, that the 3-month time limit is preventing people from bringing claims in relation to ongoing incidences of harassment. There are ways in which those claims can be brought by arguing that those issues of harassment are a continuing act, but the problem is that that is always open to challenge. So we are expecting the government response to say that those time limits will be increased from 3 months to 6 months, but that's certainly not confirmed at this stage. Pregnancy and maternity discrimination. Now, of course, this is particularly key at the moment because employers are making, unfortunately, a lot of people redundant at the moment. And when employers are making people redundant, it is important that we don't forget about the protection that women who are on maternity leave have, or the additional protection that women on maternity leave have. So that is covered by this piece of legislation, which I do trust that you are all aware of, is the Regulation 10 of the Maternity and Parental Leave, etc. regulations. And that's not me being lazy, that's actually what they're called, etc. regulations 1999. So, and this is the fact that if an employee is on maternity leave and she's placed at risk of redundancy, she must be given preferential treatment in relation to any suitable alternative vacancy over any other employee. Okay, so it doesn't matter whether she's the best employee for that alternative vacancy, she must get the job. Now, what the proposals are in relation to the change in the law, and you'll probably again remember that this is going back probably about 18 months, 2 years ago, that under the Theresa May government, the announcement was made that they did intend to change the law to extend the protection to when the employee notifies their employer that they are pregnant, to then the 6 months after the end of the maternity leave. So that's quite an extension of time. That's in reality, that's probably a good additional year of protection that employees would get under that proposal. Now, nothing has happened since. It was in the Queen's speech at the turn of the year, or I say at the turn of the year, at the end of 2019, under the new Boris Johnson government. But nothing much has happened since. So as you will see, that there has been pressure from private members within Parliament to get this pushed along, because nothing is happening. And again, it's likely that nothing is happening because the government is, of course, otherwise occupied with the coronavirus epidemic and how to deal with that. But as you can see, very recently, on the 8th of July of this year, the Pregnancy and Maternity Redundancy Protection Bill was reintroduced. And so we are expecting to see some movement on this in quite shortly, but nothing at the moment. So we don't actually have an intended introduction date, but certainly it's something that we expect to be introduced. Now this one, it's a little bit further on down the line, I admit, expected in 2023, but as I said, it's amazing how time flies, and before we know it, we'll be there. But this is leave for neonatal care. So this is again the sort of natural extension of following the introduction of the parental bereavement leave and pay, is now introducing leave and pay in instances where babies are then unfortunately taken unwell after their birth, and therefore are needing the support of their parents during that period of time. So as you can see, we've had a consultation period between October of last year and March of 2020. Now, this expectation that I've set out here is from the outcome of the government consultation. So this is what we're expecting it to look like. We don't have any draft legislation or anything on this quite yet, but we're expecting that for parents of babies who are admitted into hospital, who are 28 days old or less, that those parents will then be eligible for certainly the neonatal leave, and they will then be eligible for the pay as well if they have the requisite meet the requisite eligibility criteria. The admission has got to be for a period of 7 days or more, and the total amount of leave and pay that will be provided will be up to 12 weeks. It's the eligibility for the leave is a day one entitlement, but the eligibility for the statutory neonatal pay is an entitlement that you would get after 26 weeks of service as at the relevant date. So in the same way that the triggers for parental bereavement pay, in the same way for statutory maternity pay, that 26-week service requirement will be the same. And of course, it will then also provide protection against detriment and dismissal for employees who are then exercising their rights under that legislation. This one's a little bit further along the line, so we're expecting this one a little bit sooner, which is the unpaid leave for carers. And this is unpaid leave, so it's 1 week of unpaid leave each year to provide care. And as you can see from the way that this is set out, it's quite a broad entitlement in terms of what you would be entitled to have the leave for. You know, this isn't about, you know, emergencies, something drastically has gone wrong. This is about literally keeping somebody company, making them some meals, helping them with some paperwork, as it says, collecting a pension or paying bills. So it's just general help and assistance, but it's only 1 week each year, and it's unpaid, as I said. Now it's unclear at this stage, from what we can tell, whether in fact this is going to have to be taken as a block of a week or in singular days of up to a week. So we'll have to wait and see in relation to that. And of course, we mustn't forget that there are many other rights to leave that that carers already have. So we've got the right to request flexible working, of course. We've got the 5.6 weeks statutory annual leave, time off for dependents for that emergency leave, but again, time off for dependents being unpaid and limited to a reasonable amount of time. And we've also got parental leave, although of course I completely accept that doesn't necessarily fit with the picture that I've got on the slide, because the parental leave is going to be in relation to where you're caring for children rather than caring for perhaps elderly parents or elderly relatives. Sorry, I'm just having a quick look at a question. Yes, there was a case some time ago where a male employee won their case because the employer had given preference to a woman on maternity leave. Is this still a risk? That's obviously going back to the maternity leave issue. There was a case, you're absolutely right, but that was a case where what the employer did in that instance was they went through in going through the selection process, they inflated the female employee's score who was on maternity leave because she'd been on maternity leave. So it wasn't quite the same. They clearly thought, the employer thought that they were doing something in line with what the regulations were requiring by giving preferential treatment to the woman, but they were giving preferential treatment to the woman in terms of the selection process rather than necessarily having an equalised non-discriminatory approach to the selection process. And then if she was selected, then giving her the automatic right to the vacancy if it was a suitable alternative vacancy. So that's where that case went wrong. So you're absolutely right to raise that as an issue, but it's okay. But you just need to make sure that you undertake the selection in a fair and non-discriminatory way, and then once you've done that, ensure that you make the offer to the of the suitable alternative role to the employee on maternity leave, and you must do that. Moving on to flexible working. Now, I'm sure we're all getting very used to flexible working at the moment, or when I say flexible working, you know, of course, working from home, and you know, perhaps I don't know how many of you have got fancy MacBooks given to you by your employer to be working from home. I'm sure it's probably not very many of you, but yes, there was an intention by the government to actually introduce legislation to place a requirement on employees to consider flexible working for every role. So not actually to simply wait for applications to be made by employees. This has gone quiet. The consultation is awaited, and quite frankly, I'm not surprised that this has gone quite quiet, because now, of course, we're in a new world, and I know all of these phrases are getting overused at the moment. But you know, a lot of us are doing flexible working. A lot of employers are now turned on to flexible working. A lot of employers can now see the benefit of flexible working, and so I suspect that legislating for this is something that is going to be very firmly put on the back burner. I would have thought. I could be proven wrong, of course, but I have been many times before, but that's what I would expect. Grandparent leave. So again, this is something that has gone quiet. We were expecting grandparent leave to be introduced. This was all announced way before the parental bereavement leave and pay came about. Yes, in 2016, government announced plans to extend the shared parental leave scheme to grandparents. So if you are an employee and you are a grandparent as well, then you would be able to get access to the shared parental leave and pay scheme in the same way that parents could do. Albeit that, of course, the take-up of shared parental leave and pay, even by parents, is relatively low. So in terms of the actual impact that this would have, I think it would be somewhat limited. It appears to have dropped off the radar to an extent, although again, we have been informed that by the government that it is still on their radar. They still want to introduce it, and so we still expect it to come at some point. Ethnicity pay reporting. Now this again is something that a couple of years ago it looked like this was a slam dunk to be introduced really very soon off the back of the gender pay reporting. Now, of course, the gender pay reporting requirements were delayed this year, or the requirement to report this year was put off because of the coronavirus epidemic again. But the ethnicity pay reporting again has gone quite quiet, albeit that, as you can see here, so we had the consultation process. The consultation ended in January 2019, which, you know, quite obviously is over 18 months ago now. And there's been no response from the government, but there has been quite a significant internal push, both within Parliament and both outside of Parliament, for this legislation to be pushed along. So we've had the private members bill that was introduced in January of this year, and we've also had a petition in June of this year to require a parliamentary debate. The 100,000 signatures has now been met on that, and so Parliament will be due to debate ethnicity pay and reporting soon. So again, it's watch this space. And certainly, I just think that this is going to be a matter of time. And in fact, a number of employers are already readying themselves for ethnicity pay reporting. And perhaps some are going to start voluntarily, albeit only internally, starting to report their ethnicity pay gap in the same way that they do their gender pay gap. This is quite a significant one. Again, it's a proposal at the moment, so we don't have any firm date on the introduction of this, but it is something that is looking like it's going to be introduced. So we have got this request workplace modification. Now, essentially, this is similar to the duty to make reasonable adjustments that exists in any event, but this is actually having a look at extending that duty, although it's not actually, as you see, it's not quite placing a duty for the employer to make a reasonable adjustment. It's a right to request workplace modification. It's switched around a little bit in terms of the obligations here. But this will apply to non-disabled employees. It looks like it's going to be applicable for employees who have been absent for 4 weeks or more due to sickness, and that then there will be the system in place similar to the sort of flexible working application, that you can make an application for a workplace modification to be made. We've been promised that a code of practice will be published on this. As you can see, there is a published consultation, so certainly when I send the slides out to you, you'll be able to have a click on that and have a look at that. But this is all about trying to reduce the number of people who are dismissed because of ill health. And that then feeds into our next slide as well, which is about improving access to occupational health. Now, the government did have a stab at this a little while ago, because you may remember that there was essentially a statutory occupational health scheme, a government occupational health scheme, which could be used. But that sort of died a little bit of a death. It wasn't really used by many employers, and it just didn't work very well. There were issues about the providers that were being used, and it just wasn't working very well. Didn't work for many employers. So the government's now looking at another way of doing it, and essentially they're looking at perhaps providing a voucher system or some sort of subsidy system for SMEs to allow them to get access to occupational health at a cheaper rate, so that then they will use it rather than simply making decisions in the absence of proper medical advice. And so again, with a view to trying to ensure that we retain more employees in employment rather than dismissing them for ill health. Sexual harassment. Now, I'll just enlarge this slide because I think you might have a little bit of difficulty reading that slide without doing so. So, sexual harassment. Now, again, this is one of those that we were expecting a lot of, or we're expecting legislation, not necessarily a lot of legislation, but we're expecting legislation, particularly in relation to non-disclosure agreements or non-disclosure clauses within, say, for example, settlement agreements in relation to harassment. We were given the strong indication that this was going to be introduced. It seemed very sensible. It was all off the back of the issues relating to Me Too, and sexual harassment had a very high profile at the time, and particularly the gagging clauses that were being used by employers to prevent employees from complaining about it by effectively paying them off and gagging them, and that this would be prevented. But we have no legislation through on this yet. There was also talk in the consultation of a recommendation to introduce a mandatory duty to prevent harassment in the workplace. Quite interesting to see how that would work. And again, you see this reference to the extension of the time limit from 3 months to 6 months for employment tribunal claims in relation to certainly harassment, and potentially even extending out to all discrimination claims. And also possibly the reintroduction, I should say, of the protection against third-party harassment, which originally did come into place with the introduction of the Equality Act in 2010, but was then shortly revoked because of the difficulties that there was in the practical application of that 3 strikes rule that was introduced. So, again, watch this space. We will keep you updated, and we'll certainly keep you updated as per our email update.